Well, welcome. And you heard a little of the last discussion, but not the early parts. But we want to start off, I think, Sir Malcolm, by asking you your general view on Parliament's role, whether it's effective, where it should be going, and also the CRAG process and whether that's made a real difference, but just some general thoughts from you to start with, maybe.
Well, thank you very much indeed, and I welcome this opportunity to share some thoughts with the committee. This committee knows better than most that traditionally foreign policy was seen as the prerogative of the government and not something with which Parliament was expected to involve itself. And there were reasons for that, and I don't think we need to go into them at this particular moment. But it's never been as absolute as the theory implied, because it's not just in modern times, but even in the 19th century, Parliament occasionally was involved. I was rather surprised to discover that when the British government decided to transfer Heligoland back to the German Empire in 1890, it made it clear that Parliament would have to give its approval to that. Parliament did give its approval, but that wasn't a legal obligation. It was a voluntary decision by the government of the day, I presume recognising the political benefit of requiring that consent. And we've seen how in more modern times the reality of many modern treaties is that they involve either changes to domestic law in order to become effective, or they require public expenditure to be spent. And indirectly, as a consequence of that, Parliament has power. It's not just theoretical power, it's not just a theoretical involvement, it has real power, and therefore governments, knowing that, not always, but on many occasions, have thought it appropriate to consult with Parliament or with the relevant people, individuals who have an interest in these matters, even while the negotiation may be progressing.
But that's because of the political benefit rather than any rules or framework of accountability.
Well, it's a bit of both, if I may say so, because if a treaty does involve the need to amend domestic law or public expenditure, then the government has no choice. It's no use agreeing a treaty with another country if Parliament at the end of the day may refuse to produce the necessary legislation. So the sensible thing for governments is to consult during that process to know whether it's going to get into difficulties or not. But I think also, that's always been true, I think what has changed is, first of all, the volume of international treaties that now do have domestic implications. Traditionally, treaties were relations between states, and war and peace, and exchange of territory, and matters of that kind. Not entirely, but to a very substantial degree. Now, the bulk of treaties are on trade or on issues that do have these domestic implications. But on top of that, there is also the change of public expectation. There is now a political expectation, a public expectation, not just of Parliament, but and not just of lobby groups, but of a wider stretch of public opinion that isn't willing to just automatically assume that because it's foreign policy, that somehow Parliament has no role and no relevance.
Thank you. Lord Judge.
What should Parliament's role be in the examination of a treaty or a treaty proposal? Can you just give us some idea of the structure that you might have in mind?
Well, at the present time, Parliament's role is essentially a scrutiny of an agreement that has been reached, and therefore exercising that role either to demand further debate or further discussion, or in certain cases, as I've indicated, it has power to block. One of the issues that is often raised, and I suspect it's going to be asked later in this session, is whether Parliament should be involved in, as it were, mandating.
That's what I'm driving at.
Well,
mandating or knowing what's going on, or yes. How should Parliament be involved, if it should be involved at all, before the treaty has been signed?
Well, I heard the part of the latter exchanges you had with Mr. Straw, and one of the questions was about whether there should be a presumption of the sharing of information if there was no public interest that required otherwise. I'm slightly more sympathetic to that than I think he was. But there are pretty severe constraints, and I don't think we should be under any illusions as to how much information it would be sensible to share outside government while a negotiation was actually progressing. I'm slightly influenced by my experience as chairman of the Intelligence and Security Committee and the way in which public attitudes have changed with regard to the sharing of intelligence issues. As is well known, until relatively recently we didn't even admit they existed, even although the Russians were well aware, as were many other people. To some degree, what we have now in relation to intelligence information and the role of MI6, MI5 and so forth is that they discuss their affairs unless there is an obvious reason not to. Whereas in the past it was exactly the other way around. You did not say a word even about where your buildings were, who your people were, unless you couldn't avoid it. Now, if that can be true of intelligence, it's difficult to argue that to some degree it shouldn't also be true of foreign policy, which is inevitably less sensitive, but less sensitive than intelligence matters.
But in the context of intelligence, there is a committee which you chaired. Should there be a committee addressing these issues?
I would have thought there is a pretty persuasive argument, because there is no point in Parliament having powers if it either doesn't have the structure or the time or the interest of individual members to carry out a useful role. And legislators in either house are pretty hard-working, and you can't, as it were, just on top of everything else, expect that degree of commitment. So the advantage of some committee with a specific function is that those who agree to serve on it would presumably have an interest in devoting a significant part of their time to that. And I think it's also obviously necessary to take into account what is likely to be the post-Brexit situation, particularly obviously in regard to trade policy. Trade is a sensitive issue. It's an issue which we have not had to have national scrutiny in the sense that we're discussing today for 43 years. If that's going to become necessary, which is expected, then that is a very different situation as to what is needed to deal with that.
Hello, please.
Point that treaties used to be about boundaries and not going to war with each other and things of that kind, and to a much larger extent now they operate in areas of domestic policy with an impact on citizens. I suggest to you that it goes further than that the whole politics of some issues, labour standards, environmental standards, has shifted to the treaty-making process, because if you want to achieve something in those spheres, then not only is it preferable to do it on an international basis, but you can end up committing your government to things it might not have agreed to do unless it was obliged to do so as part of an international treaty negotiation. Hasn't that left Parliament behind, failing to exercise influence when really significant decisions are being taken?
Well, I think a sensible... I mean, most of treaties we've provisioned normally talked about the Foreign Office, but of course the more that treaties deal with other issues, trade and regulatory matters, other government departments, other government ministers are involved. And it already happens to a significant degree, perhaps it should happen more, the degree of consultation particularly with the devolved administrations, where these are not reserved matters, or with other interested outside parties. That should become standard. But there is a crucial difference between consultation and requiring approval. And I think that's where the most sensitive issues arise.
And no one can expect to require approval other than of a general mandate.
Well, I'm including a general mandate for reasons I can explain if the committee wishes me to.
So there's the implication of that in your view it would be unwise for Parliament to have the ability to amend the government's general mandate for discussions it was embarking on. Let's say to make a trade treaty with the United States.
Well, I think at this very moment in time we are all conscious of the difficulties that arise if you try to amend a treaty that the government has agreed with other governments.
It's amending the mandate I'm talking about at the moment, where no treaty yet exists. Let's take trade with the United States. We have to devise a treaty if we have left the EU. And we may have some people will have views about the health service or chlorinated chickens or whatever.
Sure.
Should Parliament have some influence in that mandate process?
Again, Mr. Beattie, Lord Beattie, you're using the term mandate. Perhaps I should comment why I'm particularly concerned about that. When the government is involved in a negotiation, it would traditionally work out its own objectives, what it believes to be in the public interest, and seek to advance these. Now, you mentioned trade treaties. In the case of the European Union, the Commission gets a mandate, but it gets it not from the European Parliament, it gets it essentially from the European government, the heads of government. And it needs that relationship. It needs a mandate because the European Commission is an unelected body, it's not an autonomous body, and therefore it needs a mandate from those who have the responsibility. Now, the heads of government in giving the EU Commission a mandate do not go back to their own national parliaments to decide what that mandate should be. That is a responsibility of government, as it would be at the national level. So in the same way, I would suggest that the traditional approach, which is that the government in this country enters into whatever treaty negotiations it thinks appropriate. I certainly believe it should inform Parliament, and we can discuss perhaps the extent to which that could be greater than it has been traditionally. But I do not myself, for reasons I'm very happy to explain, believe that the concept of a mandate from Parliament or from any element within Parliament would be in the public interest.
Do you want to elaborate?
I'll be happy to do so. I think it's for reasons both of principle and for reasons of practicality. From the reason of principle, I think that a government that is known to require in advance the approval of Parliament speaks with less authority during these negotiations. It reduces the authority of the government in the negotiations. And I can give a specific example. When I was in government, and the Danish government was always in a situation when, even when ministers had reached agreement on some proposal, the Danish government had to say, well, yes, we can agree to this, but we can only agree to it subject to going back to our Parliament and Parliament approving. And that seriously impacted upon the authority and credibility of whatever the Danish government was saying. And, of course, it also implies that if you've been given a mandate and you wish to depart from that mandate, then in the middle of the negotiation you have to go back and forward to your Parliament in order to say, can we please change the mandate that you've given us, which is very often, at the very least, inconvenient, to put it mildly, and sometimes entirely impractical if you hold up the whole European Union process for that purpose. But there are additional practical problems as well. When we say Parliament should give a mandate, what do we mean by Parliament? Do we mean it will need the agreement of the House of Commons and the House of Lords to provide that mandate? And is that mandate going to be provided by the full House of Commons voting on every treaty that the government is contemplating negotiating? Or the full House of Lords? Or is it going to be a committee of the House of Commons or the House of Lords, which is the much more likely scenario? And if it is only a committee of the House of Commons or the House of Lords, is it really necessarily right and in principle that an elected government should be told its mandate not by a whole chamber but by a committee of that chamber, which will neither have the experience of the government department, unless we're very fortunate in who makes up that committee at that particular moment in time, and in any event, that committee, if it's a normal committee of either house, will meet occasionally. It's a part-time job of supervising these matters. And I just don't think it is remotely practical or sensible to try and proceed in that way. But, and forgive me the length of this response, there is one other very major consideration that I would also draw attention to. And it's highly relevant at this moment in time. The nature of any negotiation involves both sides knowing that at some stage they're going to have to offer compromises. And you do not announce these compromises in advance. You keep them in reserve for when and if they are required. And one of the actual hard examples of the problems that can arise, we're very familiar with at this very moment in relation to the Brexit negotiations. That we've had no knowledge at all of the compromises that the European Union may be willing to make in the final stages of this negotiation, because they've been under no pressure to disclose any of these possible compromises for reasons that we can all understand. It's not such a huge issue in their national governments. In our case, our Parliament, our press, our public have said to the British government, they'd have said it to any government, yes, well, this may be what you're seeking to achieve, but what are your red lines? What are the compromises you'll be prepared to make? What are the ones you won't be prepared to make? And government has found it politically impossible. It could have said, refuse to tell you, this is a negotiation, it's against the public interest. But in reality, the government has constantly had to reveal, disclose, acknowledge concessions that either has made, is making, or is willing to make, or will never make, it says, until sometimes it's made them. Now, all of that has created an asymmetrical negotiation, and people must come to their own judgment as to whether the public interest has benefited from this, or indeed whether it was avoidable. I'm not necessarily criticising what's happened. Such is the importance of the EU issue, the Brexit issue. It would have been unrealistic to believe that the government could have conducted this as a private negotiation without telling anyone. But it would be infinitely worse if at each stage the government had to come to Parliament and said, can we please have a mandate to make these compromises or these concessions, or to keep in reserve, will you please not tell anyone, but one of the compromises we might be prepared to make is X or Y. It wouldn't work, it wouldn't be kept confidential, and the public interest would suffer severely. And although I'm using quite strong terms, I don't actually think I'm exaggerating the problem, but no doubt those who feel I am will tell me so.
Thank you. That was interesting. Lord McGregor.
Could I follow this up in the context of the EU? We have received evidence that while the UK has been a member of the EU, it has benefited from the scrutiny of proposed new international agreements carried out by the European Parliament. Now, does the loss of those scrutiny processes post-Brexit require Parliament to create new security mechanisms of its own to replace them? The Foreign Office, in its evidence to us, said that the government stands ready to engage in discussions and consider arrangements to strengthen parliamentary scrutiny of treaties within the framework of CRAG, and then rather cunningly added, should there be the requisite appetite and capacity in each house, and you've referred a bit to this. Can I just ask you whether you think it's desirable to have some replacement for the loss of that scrutiny in the European context? And in particular, to ask you whether we all know how very busy parliamentary members of Parliament and even the House of Lords are all the time. Do you think that Parliament has actually got the appetite and the capacity to deal with that suggestion?
Well, I certainly believe it's desirable that if we leave the European Union, that huge volume of treaty material which has been dealt with through the European Union organs, which will become a national responsibility, there must be an appropriate response in terms of parliamentary scrutiny to handle that. And the single most obvious example is trade, where we've had no responsibility at the national level at all for 40 years, and now we'll have exclusive responsibility and so forth. So I think, yes, there is. Will Parliament be able to respond to that effectively? As with all such questions, it's a question of how much priority Parliament chooses to give it. There's no shortage of expertise, either in this House or in the House of Commons, of people who have either have been ministers or who have an interest in these issues, and who could make a very important contribution. So it's a question of individual and collective parliamentary choice as to whether this is a priority. My personal hope is that they will see it as a priority and respond accordingly.
Baroness Causton.
Thank you. You seem to be suggesting that if Parliament played a more active role in the mandating and negotiating phases of the treaty process, it would be, from the government's point of view, as you said, inconvenient and impractical. Is there any stage in the treaty process when you think that Parliament's input would actually strengthen the government's hand?
Well, first of all, I didn't say it would be inconvenient. I said it would be very seriously damaging, and not just to the government, but to the public interest. Because that is the only relevant consideration. But yes, I do think there are ways in which I am not arguing against not involving Parliament. My concerns have been specific to the question of whether Parliament's approval in advance should be required to determine what the government's negotiating objectives are. That is approval is required. Now, that is a quite separate question as to whether it would be wise or unwise of the government to be much more open with Parliament, insofar as it felt able to do so, with regard to its negotiations, what it's seeking to achieve. And traditionally, governments have kept us very much to their chest and have not shared very much information. And I think there is scope for that being substantially greater. But there is a huge difference between consulting, inviting Parliament to offer views, sharing information with Parliament, and requiring in advance their approval. The role of Parliament, in my judgment, is very often to give or withhold its approval once the government has completed a negotiation, and because the government knows that that approval will be required in many cases, then that influences the very way in which the government is prepared to either make compromises or concessions or seek objectives that might be very controversial in Parliament.
Is there, in your view, any stage in the treaty process when Parliament's input would strengthen the government's hands, and indeed civil society, if we're looking at, for example, our position now post-Brexit with trade treaties?
Well, it would only work if the Parliament was unusually unanimous and the government was able to say, on this particular matter, not just the government's, because the government normally has a majority in Parliament. If the government is able to say that on this particular issue the opposition is as enthusiastic as we are about this objective, yes, that undoubtedly would help. It would only help if it mattered. I mean, from the point of view of other governments, if you think when we're negotiating with the French or the Germans, we're not necessarily that interested as to how big a majority they would get in their Parliament. What we want to know is, would they get a majority? As long as they get one, then the size of it is their domestic problem, not ours.
Okay. Baroness Strake.
Yes, thank you. Well, in response to Lord Beith's questions, you very clearly gave us your view on the executive prerogative in setting the mandate and the complications in the negotiation phase. But returning to the question of to what extent would a parliamentary committee on treaties be a useful forum for scrutinising the government's treaty actions, if you believe it would be useful, what powers and functions do you think it could have in the mandating and negotiating phase?
Well, first of all, I do think it would be useful, and whether it should be a joint committee or a committee of each house is not for me really to offer a view on. I don't really have a view on that. But in terms of what their role should be, of all the various treaties there are, some are very technical and not necessarily of other than limited public interest, although they're really necessary. Others are of profound public interest. And so the first function of such a committee should be to have a look at all the treaties, but to make its own judgments as to which deserve much greater attention and scrutiny. And that's one of the reasons why they're going to be there. Now, that already happens. I mean, in the sense, select committees and other committees already have to choose their priorities. They haven't got the time to devote equal attention to everything that, in theory, they have a responsibility for. So, in that sense, it should not be a difficult structure, because it's not going to be, I would have thought, that different from the structure that already exists for other issues.
And would, in your view, the kind of functions that such a committee could discharge vary according to the type of treaty that's being considered? trade treaty, a security treaty?
Well, it's a good question, that, because if we assume that a substantial chunk of future treaties will be trade and a substantial chunk of treaties will not be, then ideally you want to have a sort of the right people scrutinising the particular treaties you have in mind. So there may be a case for some either committee or subcommittee purely concerned with trade issues, for example, on which the people who serve would be, if you could acquire such people, people who had real experience of trade policy and trade negotiations. It's a very specialist skill which I don't pretend to claim I understand. But such people are available, and if they were willing to serve, I mean, normally when you think of a select committee or a specialist committee, it's dealing with a finite area of policy. It's defence, or it's education, or it's taxation, or public expenditure, whatever. When we're dealing with treaties, you're not dealing with a subject, you're dealing with a series of legal instruments which can cover any or all of these. And therefore, it may be unrealistic to believe the same people on a particular committee would be equally competent or useful in providing the level of quality of scrutiny that you want to see.
But you could have a committee that acted as a sifting committee,
yes,
and made suggestions as to which select committee or other committee could look at those things.
That's right. I mean, I was very, very briefly, many, many years ago, before I became a minister, a member of the European Scrutiny Legislation Committee. And in a sense, it was doing that. It was everything came before it, and it was a first consideration of what might require further deliberation and what didn't. Very boring work, as I recollect.
Could you ever entertain a situation where, even on an in-confidence basis, a parliamentary committee could receive quite detailed reports on the delicacy of a set of negotiations?
Could I conceive? Yes, I could conceive of it, but I'm, as you can tell, rather cautious about it. It would depend on why you were doing that. For example, if the government was negotiating a treaty which, because it involved domestic law or public expenditure or for some other reason, was going to require Parliament's approval eventually, then it might make sense, if I was the minister doing that negotiation, I might wish to go to not necessarily the whole committee, I might wish to go to the chairman of the committee and in private say, look, we're going to be making certain compromises or certain concessions, and this is why we believe this to be in the public interest, but I must ask you to keep that confidential. Now, again, sorry to go back to my ISC Intelligence Committee experience. That's what occasionally happened, I remember, on intelligence issues, that the Foreign Secretary or the Home Secretary, perhaps even the Prime Minister, might occasionally not feel able to share with the whole committee some information because of its sensitivity. But I, as chair, occasionally was asked to have such a discussion, and my committee then, although it didn't know the detail, if I came back and said, look, I think the government are not being unreasonable here, I can't explain to you entirely why, but I think they're being reasonable or unreasonable, they would accept my judgment on that. Now, it didn't happen very often, and I don't think it should happen very often, because normally the chair should not be a substitute for the committee. But if we're dealing with highly sensitive issues, then that might be different.
Lord Norton.
You've already made clear that when it comes to negotiations, you leave it to negotiators. They should be able to negotiate, if necessary, in private, not have their hands tied. But would there be conditions in which stakeholders, indeed Parliament, might have a role to play, be useful in having some input? So really the question comes back to this point about transparency. How much transparency should there be in the actual process?
Perhaps it depends on the kind of treaty negotiation we're talking about. If it's a treaty negotiation on a subject that is already in the public domain, then if the government is sensible, it will indeed not just wait for, but invite stakeholders, NGOs, other interested parties to offer their views. and perhaps should do that considerably more than happens at present. I'm not an expert in what happens at the moment, but that is desirable. Some negotiations, however, are not about matters in the public domain. Mr. Straw was mentioning his experience with Gibraltar. I had a similar experience when I was Foreign Secretary, when the Argentine Foreign Minister contacted me, who I knew reasonably well, and he contacted me and said his government had some very new proposals they wanted us to consider that might resolve this is obviously after the Falklands War, so this was in the 1990s, and we had a series of meetings ending up with a weekend at Chevening when the Minister and his colleagues and I and my colleagues, I had the approval of my Prime Minister, I even had the approval of Lady Thatcher in order to protect my back. And we had present not just myself, but we had insisted, and the Argentinians had agreed to it, representatives of the Falklands Islands Council, who up till then they would not have accepted, had any legitimacy in the matter. Now, sadly, as in Mr. Straw's example, it did not lead to a breakthrough, but it made significant progress in improving the bilateral relationship between our two governments. Now, none of that leaked. None of that was in the public domain. And it would have been very foolish for it to be in the public domain, because any chance we might have had of seeing some even more substantial progress would have been jeopardized.
And so the key point I think you're making, distinguishing between those two types, is that ultimately it must be a question for government as to how transparent it is.
Yeah, this may sound very old-fashioned, but I think sometimes you have to trust it is an elected government, after all. It is a government which is ultimately accountable both to Parliament and indeed to the public. And so you have to trust the Prime Minister and ministers, if not all the time, at least most of the time. And as long as ultimately they will have to explain to Parliament what they did, why they did it, and why they thought it was right. And Parliament can then either censor them or agree with them. Yeah. That seems to be the proper way the system should operate.
Well, Panic, you wanted to follow up?
Just ask, is there not, would you agree, a role for a presumption of openness? Because it would focus the mind of government on whether there really is a need in the particular context to maintain confidentiality.
Broadly speaking, I agree with you. I don't have any problem with the concept of a presumption of openness, as long as it is the government ultimately determines how far it can go. That it doesn't have to negotiate that.
No, I accept that. Can I ask you about one other matter? You've recognised there could be a greater role for Parliament in relation to treaties. You've explained the limits of that. Would you apply the same principles or similar principles to the devolved legislatures?
I think you have to, because the whole principle of devolved government is that although Parliament has not given up its ultimate sovereignty, Parliament can overrule devolved. It's the last thing you wish to do. It will always create a political crisis if you were to do it. So for any treaties that require domestic legislation in the devolved areas, it's not a question of being willing. You have no choice but to discuss with the devolved administrations what you are doing and why you hope they will be able to give their consent. And if they were to indicate in advance and their consent would not be forthcoming, well, government would then be in quite a serious situation, because then if it ploughed ahead with the treaty in question, it could do that, legally it could do it, but it would have to anticipate a serious political crisis unless the devolved administration ultimately changed its mind. So these are the essence of political choices. There's nothing improper about what I've just been saying. That's the essence of politics. And devolved administrations are as willing as UK governments to play politics and to make threats or promises or whatever that may be less certain than they would imply at first. So there is a chemistry involved there. But the short answer to your question is yes, they have to be involved, and their consent has to be obtained if it involves their legislation.
Lord Norton.
You heard me put this question to Jack Straw. Now, treaties, once they're ratified, they may not have the effect that they're expected to have. So do you see a role for Parliament engaging in essentially post-implementation?
If it's got the time and the willpower to do so, yes. And not just post-scrutiny, but there's also been some question about if you're going to withdraw from a treaty. Now, there, I think, even more than a new treaty, Parliament should be involved. You're dealing with a situation that's already a public matter. It's already a matter of public policy. The government of the day, if it wished to withdraw from a treaty, then I can see no reason of the public interest why it should not be fully transparent with Parliament as to why it's seeking to do that. Indeed, Parliament will insist on it in any event. And if it's going to insist on it, it's much better to volunteer.
Yeah, okay, thank you very much.
So, Malcolm, thank you very much. That's been very interesting. I have to say, I think it was very useful for our purposes. So thank you very much indeed.
Thank you very much.